Welcome to MASB's Legal Literacy, where we briefly cover legal information for school board members. I'm Brad Banasik, MASB's legal counsel, and today I'll be discussing ethical conflicts of interest. Unlike financial conflicts of interest, ethical conflicts are not defined by law. An ethical conflict of interest could arise when personal interest place a board member in a position where they cannot carry out the public duties of their office without affecting their private interests. Thus, in situations where board members have doubts as to whether they can act impartially and solely in the public interest in regard to an item or an issue that is before the school board, board members should withdraw from deliberations on the matter and abstain from voting on it due to an ethical conflict of interest. While a school board member isn't required by law to abstain from voting on matters that involve ethical conflicts of interest, an abstention for an ethical reason isn't a violation of a board member's oath of office, as some would suggest. The oath states, in part, that a school board member will faithfully discharge the duties of the office. Granted, it is the duty of a school board trustee in Michigan to vote on motions and other items of business required for board action. However, school board members also have a duty to avoid being placed in a position of conflict and to refrain from using their board position for personal gain to the detriment of furthering the best interest of the school district. In balancing and reconciling these two responsibilities to determine if one prevails over the other, it would be an illogical interpretation of the oath of office to arrive at a conclusion that requires school board members to vote on issues that are intertwined with their private and personal interests. If you have any questions about ethical conflicts of interest, please contact the MASB Legal Department.